Any mention?
Yes. With Lordship's indulgence, to make a mention for moving an unlisted matter, there is an urgency in the matter because what has happened, short story. I think my learned seniors, present on behalf of the respondents, they are here on caveat. Limited issue, pertains to removal of the petitioner from office. There was a review filed.
You are mentioning a writ petition.
It's a civil revision.
No, my lord. Anyway.
This is civil revision.
You
are agreed by your order passed by?
what had happened is we had filed a suit along with an injunction application, rejected. We went, first appellate court granted an injunction, A third party, who is not a party to the suit, came and filed a review, who my learned senior is representing. And my injunction is vacated. Now, not only is the injunction vacated, there are certain observations made in that order which basically render my suit infructuous. Now, based on that, I have been served with a notice yesterday, whereby, I have been summoned for an inquiry today, at 11:30 in Guwahati, which is the reason of the urgency of the mention,
No, my lord, here your lordship will appreciate one thing, my lord. I have filed a review. An injunction was for limited injunction up to 30th April. Up to 30th April, then injunction was there. But suppressing some relevant facts, I filed a review application. That was recalled.
Mr. Paul, not possible.
And then they appeared, my lord.
Matters already filed, we were anticipating it to be listed in normal course, but unfortunately, it did not get listed.
And my lord, this
I
matter
am
was
here
fixed on
before your
30th.
lordships only for a very limited issue, that at least my suit should not be made infructuous. I've made this.
It's okay. We'll just sit it. We'll just sit it.
Well,
raise your points. Just let us take up the note.
Highly obliged.
It is filed already, isn't it?
Already filed, filed, registered as well.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. I pray for 2 weeks' time, Your Lordship.
Why next week?
Not ready with the matter, Your Lordship.
This is 2023 matter. Why? Yes.
No objection, your lordship.
2 weeks on the prayer of the petitioner. Yes.
Highly obliged, Lordship.
May it please, Lordship. Lordship,
Yes.
I beg to make a mention of item number 13. I've taken consent from the petitioner.
Yes.
2 weeks.
Why? Why 2 weeks?
Lordship, conducting counsel has some personal difficulties to tell us.
2 weeks on the prayer of the respondent. Yes. You are appealing for respondent, all the respondents.
Only one, Lordship.
Who are the other respondents?
It's proceeding expert, Lordship.
Your respondent number?
1.
This will be on prayer made on behalf of the respondent.
Obliged, Lordship. Lordship, a similar prayer for item number 16.
Item number?
16. No objection, Your Honor.
Second will be on the request of the petitioner after 2 weeks. Okay.
Highly obliged.
May it please, Your Lordship, I beg to mention item number 8. Your Lordship, it's a joint request from the respondent as well.
My lord's joint request.
And joint request made with the parties. List after 2 weeks.
Highly obliged, lordships. Supplementary cause list, item number 1.
May it please, Your Lordship.
Yes.
This is a writ petition, my lord, challenging the impugn order. Lordship, briefly, I am a BSF constable, my lord. I was posted here at Borsora market near the border. Now, my lord, on 2nd of September 2023, a certain incident of smuggling had occurred. Now, there is a claim and counterclaim, my lord. Now I was present at the market. I say that I tried to stop the smuggling.
You are on duty.
I'm on duty. I say that I tried to stop the smuggling. And as a result, there was an altercation in the market with one public,
What was the smuggled item?
Smuggle item, my lord, liquor.
And there was seizure. Was
No,
there
no seizure. They were going through a drain through the.
No, whether could you seize the smuggled item?
No. I was trying to stop. So anyway, my lord, there was some altercation with one civilian in the market. Now thereafter, lordship, what happened is, by the time I went back to my outpost, my battalion, to report that this is what had happened, it turns out that this civilian.
How far your post and
No, my outpost is in Borsora. My battalion is here in Mopat.
no, but then you were that time you were discharging functioning where?
In Borsora outpost.
You are discharging your function, your duties where?
Borsora market, lordship.
Borsora market.
Yes,
You were detailed for duty in Borsora market.
lordship, yes. In OP2, OP3, they have outposts there.
Outpost 1, outpost 2.
Lordship, yes. So I wanted to come and inform to my COI commander, who is also there. He is the
Where?
in Borsora only, lordship. But in the meantime, before I could reach from the market, this civilian whom I had allegedly had an altercation in the market, he also came to the COI commander and he lodged a complaint.
The person whom you suspected to have
Involved in this thing, he was a civilian.
no, you just whom you have suspected to be a smuggler. That one is it?
Lordship.
Is it the person?
Yes, yes.
So he reached the outpost before you.
He reached the outpost before me.
Okay.
He made a verbal complaint to the COI commander saying that he was threatened and assaulted in the market area by the BSF personnel, lordship. And he said that I had also brandished a gun and so on, tried to threaten him. So thereafter, lordship, at the same time, I also reached more or less at this immediately after that, and I was asked by the COI commander as to what happened. And when I tried to explain that this is what had happened, and it was not a case of picking up a fight with some civilian and so on, instead, my lord, unfortunately, the situation became a little untoward, and I happened to have uttered some words against my COI commander also. So, lordship, disciplinary proceeding was drawn against me, and I was tried under the Summary Security Force Court, where I pleaded guilty, lordship. I pleaded guilty, and punishment was given to me. Now, I am aggrieved with the punishment, lordship, here on proportionality. 2 punishments have been given to me. One is 89 days of rigorous imprisonment, and at the same time, I have been asked to forfeit 1 year of service for the purpose of promotion. I have already served, my lord, the imprisonment part.
Then what remains here to challenge?
I am aggrieved with the forfeiture of 1 year service, lordship, on the ground that it is not proportionate to my lord, my misconduct.
Is it? Now, what was the charge against you under what section?
Lordship, that is under the BSF Act only, 16D, 20B and 40.
And what could be the sentence?
Lordship, sentences are of imprisonment only.
No, that is okay. Then what about your sentence so far as the
Forfeiture part.
your yes forfeiture?
There is a provision under the BSF Act only that they can give a apart from the sentences mentioned in the offending sections, they have a blanket section also for giving punishments which they can pick and choose and give any of those in addition to the original punishment.
addition to your conviction in the.
Yes.
So then what is wrong in it?
I am on the ground of proportionality, lordship. That for a small incident.
Okay, we'll issue notice. Yes.
Lordship.
File active. Hard. Deployment council. The petition. Issue notice. Returnable in 3 weeks. Dr. Mochiga.
All the response 1 to 4.
Along appearing with so and so. Along with so and so. Along with so and so appears for all the respondent, and hence no formal notice is called for. The respondents to obtain the learned counsel appearing for the respondent to obtain necessary instruction before the next date. List after 3 weeks. Yes.
I am obliged.
Daily cause list, item number 1.
Yes.
May it please your lordship. Your lordship, an affidavit bringing on record has been filed by us on the 4th of May, your lordship, and I have enclosed the certificate in page 5.
Anyone appearing for respondent number 4? No.
No one, your lordship. This is the second time, your lordship, we have been taking steps.
Oh, there is CMJ University.
Yes, my lord.
Yes, your lordship.
So what is to be done now?
Your lordship, let this matter will come up for hearing, your lordship, for final hearing.
You filed your affidavits.
We've already filed, my lord.
They have already filed a rejoinder, your lordship.
Okay. An affidavit. It is submitted by the Learned Counsel for the petition, and that an affidavit showing the effectum of delivery of notice upon the respondent number 4 has been filed. Step, however, there is no appearance on behalf of the said respondent when the matter is called out today. You are appearing for respondent number?
3, my lord.
And who is appearing for 1 and 2? So you have filed your.
We've already
respective
filed, my lord.
affidavits.
We've already received rejoinder as well.
Okay, Learned Counsel appearing for the respondent number 1, 2. And respondent number 3. Submits that the affidavit on behalf of the said respondent has already been filed. Step. Paragraph. As straightforward with the parties. This is matter for hearing. After?
Pardon, your lordship.
After? When do you want it for
3
hearing?
weeks, your lordship.
After 3 weeks. Okay.
Much
Much
obliged, my lord. Item number 2.
In this case, I'll be filing my affidavit within 1 week, your lordship. I've already prepared almost everything is done, but only 1 week's time may be given. I'll be filing within 1 week's time.
Chaplain Vanerjee appearing for the state respondents. Further 1 week's time is granted for filing affidavit in opposition.
I'll be obliged.
Yes.
Item number 3.
May it please your lordship. Lordship, in this matter, we were supposed to file an objection. Lordship, I'm seeking some more time, your lordship.
That is a condemnation petition.
Yes, your lordship. There's a delay of
Instruction,
about
these are small things.
423 days, your lordship. There's a delay of 423 days.
423 days.
Yes, your lordship. Your lordship, 2 weeks may be granted, lordship.
No objection.
On prayer made. MS Groom, counsel appearing for the respondent. 2 weeks time is granted for filing objection.
Hearing item number 4.
May I please?
Yes.
Earlier your lordship heard this matter and passed certain direction to file affidavit. Here the writ petitioner is praying for before your lordship for a direction to pass an order for consideration of his promotion under the 17%. He is a constable recruit, your lordship. 17% quota of limited departmental competitive examination. And it is all the central paramilitary force are holding this examination. This policy came out from the Ministry of Home Affairs. And your lordship knows Assam Rifle is one of the paramilitary force under the Ministry of Home Affairs. Only in the circular, this Assam Rifle is not marked. But what happened, there are provision from the constable, they can appear provided they are graduate and within the age limit. They can appear in the limited competitive examination under 17% quota in the cadre of assistant commandant as well as in the cadre of sub-inspector. A sub-inspector is known in Assam Rifle as Naib Subedar. So, this is my prayer in this writ petition. The last order your lordship passed on 6/3/2025.
25, this matter was heard.
Yes.
It's more than a year.
Yeah,
Mr. Chandok.
I'm refreshing your lordship. Lordship may come to my prayer.
Lordship, please, Lordship, the only difficulty is, Lordship, we are not prepared today, Lordship.
You're not prepared. He has come from outside.
Lordship, if the petitioner may submit today and if we can reply.
No, that is, we do not want to do anything in piecemeal. If he's outstation lawyer, you know, if you had any difficulty, you should have informed him.
No, my lord, actually I have come for this petition, only for
That
this
is what,
case.
that is what we...
And I have come yesterday, your lord. Lordship, I can submit the facts, my lord, and they can reply, your lordship. I will appear through BC, my lord. I am just...
It's a difficulty, Mr. Chandu. Just, you may argue the thing and you may finish, but then it's difficult for the court to keep everything in mind, you see. That is what the problem is.
Even lordship, I'm just only drawing your lordship's last order, 6/3/2025.
Have you prepared notes of argument?
Notes of argument.
Do you have a...
No, notes of argument was not prepared. And lordship's order, lordship may look into just have a 6/3/2025 order. 6/3/2025. 6/3/2025. I'm reading it, my lord. 6/3/2025. And they have filed an affidavit, not by the respondent number 1, as your lordship directed, to file by the respondent number 1 Secretary, Ministry of Home Affairs, filed by a staff officer of the DGR, disputing the claim of the petitioner.
Yes.
6/3/2025.
Yes.
May I read it, my lord?
Yes, you can read it.
By this application, the writ petitioner, who is serving as rifleman in GD in the Assam Rifle, has sat for consideration of his promotion to the post of Naib Subedar GD through limited departmental competitive examination LDC under 17% quota in the light of the Government of India MHA circular letter issued by the Ministry of Home Affairs number so and so dated 21/8/2000, then 16/4/2010 and 9/7/2012. Learned counsel for the petitioner submit that the Assam Rifle is a central paramilitary force, CPMF, under the Ministry of Home Affairs and is an identical force like CRPF, ITBP, BSF, CSF and SSB. And the guidelines issued by the aforesaid circular letter have been implemented in all the police organizations falling under the Home Ministry, but only the Assam Rifle has been left out. He also contend that the Assam Rifle has applied the above guidelines for providing promotion through LDC to the rank of assistant commandant, but has not implemented the same for providing promotion to the cadre of Naib Subedar, sub-inspector in other CPMF without any reason or justification. Per contra, in the affidavit filed by the respondent number 2, a stand has been taken that the Assam Rifles, because of its distinctive organizational structure, cannot be treated at par with CRPF, ITBP, BSF, CISF, SSB, and hence no parallel can be drawn between the Assam Rifles and other CPMFs. Since all the CPMF, including the Assam Rifles, fall under the Ministry of Home Affairs and the benefit of policy conveyed by aforesaid circular letter are issued by the same ministry, this court deems it appropriate to direct the respondent number 1, the Union of India, through the Secretary, Ministry of Home Affairs, to file an affidavit as to whether the policy guideline formulated by the Ministry of Home Affairs by letter number so and so 21/8/2000.
Okay. They filed thereafter.
No, they have filed an affidavit, and that is by a staff officer. Your lordship.
It's by the same. It's not required that there is no personal allegation against the Secretary, Minister of Home Affairs.
No, your lordship
The
directed
purpose
to.
was basically to know whether those letters should cover Assam Rifles or not.
My lord, I
What the affidavit says?
affidavit says that Lordship, there affidavit para 5, one staff say para 5. Yes. There says, my lord, it is informed that MHS para 4 I am reading. The deponent states that in compliance with the order dated
Wait, just a minute. Wait for the court to reach. Where is the affidavit? What is the affidavit? When was it filed?
it was filed on 23/5/2025.
It was filed on 26th of May, Your Lordship.
Okay, and what is the relevant paragraph?
Relevant paragraph 4, my lord.
Yes.
That the deponent states that in compliance to the order dated 6/3/2025 passed by this honorable court, the Police 2 Division per Policy Section, Ministry of Home Affairs, New Delhi, by letter number so-and-so dated 25/4/2025, as stated as follows. It is informed that MHS letter number so-and-so dated 9/7/2012 has been issued on the basis of scheme circulated by MHA, letter dated 21/8/2000, and letter number so-and-so dated 16/4/2010, which is related to relegation policy for assistant commandant and sub-inspector in the Central Armed Police Force. The said policy is applicable for the post of SI and SE only in CPFF, BSF, CRPF, CISF, ITBP and SSB. The said policy also does not mention either the post of Naib Subedar or GD through LDC or the applicability of these guidelines on Assam Rifles. Further, it is informed that as per MHS letter number 22/3/2011, the uniform nomenclature of CPF only include BSF, CRPF, CISF, ITBP.
Paragraph 5, they have taken categorically, does not include Assam Rifles.
My lord, now I'll show. This statement is totally false. I'll show you, Lord. Lordship, in my writ petition, page 12, my lord. In my writ petition, page 12. Under the same policy, Assam Rifle conducting 2 examinations. This policy of Ministry of Home Affairs, one for assistant commandant and one for sub-inspector.
Your claim is for the post of sub-inspector.
Sub-inspector, this is Naib Subedar. Now, assistant commandant under the same policy they are holding. Assistant commandant under the same policy.
How do you say they are holding under the same policy? That is what you show us.
No, that is what. Page 12, your lordship. Because this is the policy. Policy, I have, my lord, policy, your lordship will find 3, 4 and 5 annexures. Policy, should I take your lordship to annexure 3, 4 and 5?
No, where, see, you can take the court
to
the annexure which would make out a case for you. You wanted to
12,
say,
page 12. Page 12.
You wanted to say that the stand taken in their affidavit is not correct.
Yes, yes.
So just show us. Which page shall you come?
Page 12, your lordship.
Yes.
Order dated 18 December 2012, Director General of Assam Rifle.
Yes.
The President is pleased to appoint the following personnel of Assam Rifle to the rank of Assistant Commandant by promotion through LDC, through Limited Departmental Competitive Examination in Assam Rifle on successful completion of their pre-commission training of OTA, Gaya, Bihar, in the paymetric level 56,100 and other allowances at admissible under rules from time to time with effect from the forenoon of 9 December 2017, along with their seniority position, allotment of AR number as per marks obtained in the final DPC and SCO course 39 at OTA Goya. Now, Lordship, these are all riflemen JD. They have been provided the opportunity of promotion under 17% quota. Now, your Lordship, these are the riflemen who have qualified in the assistant commandant. I am seeking for sub-inspector. And in the authority, your Lordship will find authority. Government of India, Ministry of, this is very vital, my lord. Government of India, Ministry of Home Affairs, approved note sheet dated 23 September 2016 and OTA Goya letter number commissioning dated 9 December 2017. The officers are allowed to take over the charge with effect from the forenoon of 9 December. So, by approving a note sheet,
Now, which way this letter is relatable to the memos
Because
which
under
are
the
referred to in that order?
yes, my lord. That is a very pertinent question, your lordship. I need to answer. Lordship will find the scheme started. Lordship, page 15 of the writ petition. This scheme. This scheme is started. This is Ministry of Home Affairs scheme, my lord.
Yes.
Page 15, my lord, of my writ petition.
Yes.
Subject, my lord, in the top, Ministry of Home Affairs, Gೃಹ Mantralaya. Subject, relegation policy for assistant commandant, GD, LDC, GD, and sub-inspector, GD, LDC in the Central Armed Forces, CAPFs, SC, assistant commandant, LDC, and SI, SI means sub-inspector, LDC, are based on the scheme circulated by the MHA by their letter number so-and-so dated 21/8/2000, letter number dated 16/4/2000. The duration of training is 24 weeks, and at the end of said separate training, assistant commandant, sub-inspectors, GD, selected through limited departmental competitive examination, LDC, will be put through a test examination to be conducted at respective training institute academy. So, this is the scheme Ministry of Home Affairs started. But this was marked, marked next page, page 16, your lordship, on the first para.
You see, so far as this order of this court is concerned, order dated 6/2025 is concerned, 3 letters were referred. One is 21/8/2000,
Yes, my lord.
another is 16/4/2010, and another is 9/7/2012.
Yes.
Now, the part which you have read out just now at page 15, is it the same which is referred there?
Yes, page 19 also, the other part, 21/8/2000. That letter is page 19, my lord. Page 19.
But then there is no mention of Assam Rifles here, isn't it?
No, here there is no mention of Assam Rifle. But with the note sheet, only assistant commandants are giving the, constables are giving opportunity, constables of Assam Rifles. Constables or Assam Rifles are giving opportunity of 17% assistant commandant. 17% assistant commandant.
Now,
Although it is not addressed to the.
if you want to say that these communications were binding on the department, then you must show it, isn't it?
My lord, because your lordship.
So supposing it, if it happens that there was some, maybe 1 or 2 instances of adherence to this without, you see, like accepting it as a policy, will it make out a
My
case for
lord,
you?
I'll place the several judgment of this court. I have given a bunch of judgments so far, I think, on the first occasion. And Dination KK judgment of the Honorable Supreme Court, 1-to-1 parity. Even 1-to-1 parity also recommended by the Pay Commission, also recommended. And Dination case, Union of India versus Dination
Madam, you sit
KK.
down, madam. You sit down.
Union of India versus Dination KK says there should be parity in all the central paramilitary force. And one just example I am showing, my lord. In my affidavit in reply.
Anyway, before you come to that, just you finish those reading these notifications and all.
My lord.
Let us
my
not jump from.
My lord. Then, my lord.
Now,
yeah,
which way you establish that this notification is applicable to the Assam Rifles?
they have adopted for the assistant commandant. They have adopted for assistant commandant. They have adopted, my lord. The first one I have shown. Adopted. They have adopted.
No, first one doesn't say that that is in adherence to that order dated. Where?
This is limited departmental competition from the rifleman GD.
No, but then where is that reference of this letter?
No reference. The proposal was sent and note sheet was approved.
But that is okay. Note sheet for a particular case. Note sheet is not a policy.
No, that is, they cannot make a policy, my lord, differential treatment towards the They will only selectively, they have accepted the proposal of holding competitive examination.
Fact remains that you are not a contender for assistant commander, isn't it?
Because my lord, I'm intending to appear
You
in the
have to confine yourself to the Naib
GG,
Subedar.
under the same circular, your lordship. Under the same
But
circular.
two different posts.
Two different posts, admittedly.
So?
Admittedly, two different posts.
So if it is-
But
if
if they, Assam Rifle, if Assam Rifle accepted assistant commandant, they should have accepted the sub-inspector also.
Why? It's two different.
My lord,
Then they do not say.
under the same policy, your lordship.
See, no, that is why.
And we are all governed by the Ministry of Home Affairs.
The page 12 has no reference of this policy of 19 July 2012.
No, it is
Page
not
12
reference.
doesn't say so. That those assistant commandant.
Let them then bring the record, my lord. Let them how this policy, how this proposal was instituted. There is some source of institution of this proposal.
But then, so far as your document is concerned, there is nothing, no indication.
No, they how? Because no sheet was they submitted a proposal, my lord. They submitted a proposal. Thereafter, it was approved by the Ministry of Home Affairs. And this policy says.
Yes, what you will say with regard to that? Okay. Where is Dr. Mojika?
Your Lordship, he's on legs currently, Lordship.
But that is a problem, you see.
My lord, and one thing I am showing, my lord. One thing, my lord.
No, see, the problem
Yeah,
Mr.
now,
Chanda,
my lord.
Mr. Chanda, we can understand. You can the thing is that, but then if you do not get a response, then it becomes a problem for the court to decide.
That is there, my lord. I admit. Only one thing, my lord. On the last occasion, your lordship, now all the paramilitary forces, in my affidavit in reply, your lordship will find, last page, all the constables are recruited through Staff Selection Commission. All are declared as CPF. All are declared CPF, and that there should be same policy in my affidavit in. That was your lordship take a note of the fact earlier, on the earlier occasion. Lordship will find page 8 of my affidavit in reply. Page 8 of my affidavit in reply. Who falls under the Central Paramilitary Force under the Ministry of Home Affairs. Page 8, Annexure A, my lord, of my affidavit in reply.
That is dated 25/10/2019. Your affidavit in reply is dated?
Yes, my lord. And Annexure 8, Annexure A, page 8. Annexure A, page 8.
Yes.
Lordship got it. Staff Selection Commission. There your lordship will find Constable GD in Central Armed Forces, CPF, NIA, SSF, Rifleman GD. Then Government of Stripes.
But then in Assam Rifles also.
Oh no, Assam
That is
Rifles.
okay, but then
CISF.
just because the Staff Selection Commission has held a common recruitment test, would it mean that Assam Rifle becomes a part of the CAPF?
Yes, my lord. Central Armed Police Forces.
But then-
Constables in the notice, just after the notice.
See, it doesn't say ITBP, BSF, CRPF, isn't it? It mentions CAPF.
Yes, my lord.
Now, once we say CAPF, that means ITBP, BSF, everything comes under that.
Yes.
But then NIA, SSF, and Assam Rifles are mentioned separately, meaning thereby they are not covered by the term CAPF.
My lord, that has been in the nation case and other judgments of this court, other judgments held, repeatedly held.
That is okay. You are coming to this separate part.
But this is, your lordship will find, all these recruitment are made.
So far as this notification are concerned, it doesn't show that this Assam Rifles basically is a part of CAPF.
My lord, I have given a
On the
bunch of.
contrary, it shows a different thing.
I have shown a bunch of judgment. I have on the last occasion, so far I remember. Lordship will look into the Dination KK. Dination KK judgment. That was there in the bunch. May I please a copy of the judgment, my lord?
Yeah, no, it is there. It is already. I think you have this, your bunch of judgments are already there. Let us.
So,
Yes, KK 2008 1 SCC.
yes, para 4, Your Lordship. I am reading para 4, 6 and 24, my Lord. Para 4, 6 and 24. My Lord, I have a highlighted copy is there, my Lord. Can I, for Your Lordship convenient, should I submit this highlighted copy? Highlighted copy. I have highlighted it for Your Lordship.
It's okay. This
No,
is, you're referring from SCC, isn't it?
SAC.
It's okay, no problem.
That highlighted.
It's okay. Para 4 6.
4, 6 and 24. 4, 6 and 24. I am reading it, my Lord.
Here also it is highlighted.
Highlighted. Yes. My Lord, I am reading it.
Yes.
The nub of the grievance of the writ petitioner working in the rank of radio mechanic in the Assam Rifle was that the Ministry of Home Affairs and the Director General of Assam Rifles, having accepted in principle that the members of the Assam Rifles should be given the same rank and pay structure as was given to other central paramilitary forces, yet the same had been denied to them. It was pleaded that as the Ministry of Home Affairs had conveyed its decision to rationalize the rank structure of non-gazetted personnel of central paramilitary forces by order dated 26 January 1998. Equal pay structure in other ranks, including radio mechanics in the Assam Rifle, could not be denied.
This is concerning rank and pay, isn't it?
No, it says, my Lord,
Not promotion.
same, it is by way of promotion. Here, they are selectively given.
The manner of promotion is something different, isn't it?
My Lord, promotion, no, this is, what is
You say
the,
rank and pay?
no, grievance of the working that radio mechanics in the Assam Rifle in the Ministry of Home Affairs, having accepted in principle that the members of Assam Rifle.
If you say rank and pay, that will mean status of a post, isn't it?
This is also, my Lord, by way of
Then
promotion.
so far as mood and manner of promotion is concerned,
They have
That
adopted
may
a
stand-
part of the,
is whether this CAPF are guided by one set of service rule or they have different set of service rule. Say for BSA, for CRPF, they have different set of service rules. For Assam Rifles, is there any separate set of service rules?
the service rule is in the name of Assam Rifle. It will be.
So they all the
Parties similar. All are similar. my
It
Lord.
means all the establishment under the CAPF, they have separate service rules.
Separate
They
service.
do not have a common service rule.
But
So meaning thereby they are guided by different set of rules.
my Lord, my humble submission, rule is BSF recruitment rule 2009, Assam Rifle recruitment rule 2009.
Names are different, but then
But name
in
they,
essence they are same.
in the same, they are same. Now even Assam Rifle taken the ACD.
Now, can you establish, so far as your claim in this case is concerned, your right to be promoted
My Lord.
under that limited departmental examination? Is it supported by the set of rules which Assam Rifle has?
No.
Keeping apart these notifications.
My Lord, here what they have done, when this policy was declared by the Ministry of Home Affairs, and it is under the Ministry of para 4, 6, 24, your Lordship will find. 6 also they have admitted before the Supreme Court. They have admitted that Assam Rifle, all are governed by this. They should be at par with each other.
So
They
far
should
as
be.
this is so far as the rank and status is concerned.
No, Lordship may look into other aspects.
That means the hierarchy of posts, isn't it?
Para 6, my Lord. Para 6 maybe.
Yes.
Para 6 of this judgment, taking note of the admission on the part of the Union India, there was disparity between the pay scales of the members of the Assam Rifles and similarly ranked personnel of other paramilitary forces. The High Court felt that it would be unreasonable and discriminatory if the scales given to radio mechanics in CRPF and BSF were denied to the radio mechanics in Assam Rifle. When qualification
There
and
is no dispute.
service requirements in all other 3 organizations, when the service requirements in all the 3 organizations were identical, consequently the High Court issued the aforesaid direction which are questioned in this appeal. Now para 24, my Lord, para 18, my Lord, para 18. From the afore extracted paragraphs of the counter affidavit and the resume of correspondence referred to above, it clearly stands admitted by the petitioners herein that all the paramilitary forces, here my Lord, Lordship,
Go ahead. No problem.
all the paramilitary forces including Assam Rifle, are at par with each other. At par with each other, and there was apparent disparity in the pay scales of the personnel of Assam Rifles with their counterparts in other central paramilitary forces. In order to rectify this disparity, Director General of Assam Rifle Petitioner number 2 herein, by letter dated 18 February 1998, had in fact taken up the grievance of the respondent with the Ministry of Home Affairs inter alia, recommending redesignation of the Havildar RM grade 1, grade 2 Assam Rifle as the warrant officer and for replacement of the scale of 4,000, 6,000 to bring them at par with their counterparts. This is important, my lord. To bring them at par with their counterparts in other central police organizations. However, the Ministry of Home Affairs, by letter dated 3rd March 1998, while accepting the said proposal, had recommended redesignation of Havildar radio mechanics as a warrant officer, but subject to the condition that revised and revised pay scale of Havildar RM in other paramilitary forces were identical to the pay scale of head constable RM in CRPF and BSF. Manifestly, in the instant case, the differentiation in the pay scale to the two paramilitary forces is sought to be achieved not on the ground of dissimilarity of academic qualification, same qualification, Your Lordship, the nature of duties, responsibilities, but only on the ground that there was initial anomaly in the 4th Central Pay Commission report. The counter affidavit does not even attempt to explain how the case of Havildar RM in Assam Rifle is different from the radio mechanics in other central paramilitary forces. So my contention, once out of that my lord SE, limited departmental competitor, you are given the same rifle constable opportunity for limited competitive, but not to the, from the same rifleman to the cadre of Naib Subedar, that is sub-inspector. That is my case, my lord. Whether under the law, even in a recent judgment passed by this honorable court, by His Lordship Justice Dingdo, they are also similar ground they have taken, that Assam Rifle is akin to army. It cannot be at par with other cases. The honorable learned single judge allowed the petition.
That is also a case with regard to promotion.
That is regarding upgradation, promotion. Upgradation. That is, my lord, that your lordship will find.
This is judgment order dated 24/9/2000. No, not 24/9. This is 24/2022.
I am sending it. I am giving it a copy of the.
Is it judgment and no? It is.
My lord, lordship, I am giving a
list
copy.
of books contains 3 cases.
No, 3 cases. It is a different case. It is subsequently judgment. Then also finally, para 15 your lordship will find. The same argument also raised. Para 15. Here also same ground is taken in this affidavit in opposition. And finally this court, following the precedent of other cases of Assam Rifle, allowed the benefit, my lord. Benefit of higher rank status. And it is rather a higher rank and status through a limited competitive examination. Through a limited...
What is the dispute involved in that case?
In that case, my lord, they were denied upgradation.
This also on implementation rank and pay structure.
Pay scale, wrong. Here also, my lord, I am coming for. I am coming for pay rank.
Matter in hand, it doesn't deal with rank and pay structure. It is with regard to scope of promotion. The present matter which we are dealing with here.
Rank and status also, my lord, by some way it is a promotion, my lord. Promotion.
But then it is not promotion, you see.
My lord, it is a, and I am showing, my lord, from my rejoinder, that 1-to-1 parity is there. from my rejoinder, the Sixth Pay Commission.
Anyway, see, Mr. Chanda, you can give us a note of your written notes of your argument, just maybe one page, only that highlighting the points.
My
nothing else. Dr. Mojika is also not there.
So I will give, my lord, from my side, I will conclude I will give a written note. I will give a written note along with the judgment highlighting.
Okay. Okay, so you want your physical appearance should be dispensed with?
No, my lord, if necessary, I will come, my lord. If necessary.
It's all right.
My lord. If necessary, or otherwise, I will appear through BC, my lord.
Okay, the court has understood more or less your case, and what else you want to follow? In this judgment, the one which you have placed right now.
Yeah, same.
What is the
para 15 your lordship will find the same ground they have taken.
Yes.
Same ground, para 15.
What is the outcome?
Outcome, finally, it is given in our favor. In favor of the employees.
Where is the paragraph? Which is that paragraph?
Para, my lord. Para 38, last para.
Yes.
Direction to bring parity in respect of pay scale rank structure of rifle of SKT EME, SKT signals, as well as Havildar SKT EME, SKT signals in the Assam Rifle at par with other central police organization by introducing the rank of warrant officer, assistant sub inspector at the anti-grade.
Yes.
At the anti-grade from the date of remastation. So even, my lord, even nowadays, all are conducted by the Staff Selection Commission. All central paramilitary forces, BSF and all these things. So they selectively, by issuing a proposal of that competitive LDC examination notification, and they only selectively, they are allowing only a part of that to the assistant commandant, not to the sub-inspector. Whether it is permissible, being a model employer, Assam Rifle being a model employer, whether it is permissible to deprive us to appear in the competitive examination for promotion to the grade of Subedar sub-inspector.
Under the LDSE.
Under the LDSE. That is exactly my.
Yes. When Dr. Mojika will be available?
Lordship, most probably after 2 weeks, Lordship.
Can come, my lord, after 4 weeks, my lord.
4 weeks, then court will forget the thing. That is anyway, if you give us a written notes, you give us a written notes.
Subsequently, Lordship will also file a written notes.
Heard Mr. Chandu, Rani Council appearing for the petitioner at some length. Dr. Majika, learned CJC, learned DSJ appearing for the respondent. It not present. Stop the hearing of the matter. As such will continue on the next 8 weeks. Stop. The petitioner will be at liberty to file file written notes of argument before the next date. Stop. The spread for next after
3 weeks, maybe.
3 weeks.
Then date, my lord. If a date is given, I will.
Court,
So I'll try to come, my
Nevertheless,
lord.
court has got the things. And
If a date is given, I'll try to come, my lord.
it's okay. You can do one thing. BC is there, and we'll see when Dr. Mojika.
And I'll place, my lord, all those judgment, current judgment also, with highlighting.
Already.
No, apart from that, some judgments are there.
So you do one thing. You make a written notes. Give the list of your judgments which you are relying on there also.
And paragraph I will highlight, my lord, so that for your lordship convenient. Deeply obliged, your lordship. Deeply obliged.
Item number 5.
Lordship, this matter I'll pray for some time.
Just a minute. The court is still holding the previous one.
Apologies for that.
Yes.
Lordship, this is an application under 482, Lordship, for quashing of the order dated 8/4.
What is the offence involved?
Lordship, here this is under the Drugs and Cosmetics Act, Lordship, section 27, Lordship, which falls under chapter 4, Lordship. We are, Lordship, on a limited issue that the FIR which was filed by the police concern, Lordship, is illegal, Lordship, because under the Drugs and Cosmetics Act, Lordship, it's a complete code which gives it's a complete code.
It is not a cognizable offence.
It is cognizable, but Lordship, what has happened here in this instant matter is, Lordship, FIR was filed by one sub-inspector, Lordship. That is not permissible under the Drugs and Cosmetics Act, Lordship.
Who should be the authority? Who can file?
Drug inspector, Lordship.
So the person who filed is he was holding the rank below the drug inspector.
Lordship. And he is
Rank
notified, Lordship, person. He has to be a person who has to be notified under the Drugs and Cosmetic Act, Lordship.
So that is the sole ground.
Lordship.
Any
The law has
authority?
been, in this regard, Lordship, the law has been clarified by the Honorable Supreme Court, Lordship.
Okay. And what does it say? It supports your contention.
Lordship.
Where is that law?
So, my lord, before my friend proceeds, my lord, I'm praying for an adjournment in this matter, my lord.
Why?
Because, my lord, I'm not the counsel here. I'm informed by my friend that Mr. Kharwanlang is the counsel. He's not available
Also
today.
government counsel, and if the issue is small, then
The only problem with difficulty is, my lord, I don't have the brief with me at the moment.
Let a short date be given, my lord.
is there any use of giving short? It is on prayer made by Mr. K.P. Bhattacharya, learned GA, appearing for the state respondents. List is made after 2 weeks. Yes. Hello.
Item number 6.
Yes.
As per the last order, the Ministry of Home Affairs is supposed to take instruction, Lordship. These are the land compensation matter, Lordship. The matter relating to South Garo Hills has already been disposed, Lordship. Now this is with
There
regard
are
to
a series of cases.
yes.
Yes.
Now with regard to South Garo Hills, that matter has already been disposed in by the earlier order. Now this is with regard to Southwest Garo Hills, Ampati. There are 2 writ petition, item number 6 and 7, Lordship. Now in this case, Lordship, there is some communication gap between the state as well as the Ministry of Home.
So far as the
Draft award,
proceedings-
Lordship.
Yes.
Draft award, Lordship.
Yes. That is the problem, madam. This case
Yeah.
is pending from 2019.
Here only we need some direction to, because here 10% of the compensation already been paid, Lordship, and 90% is that admitted by the government in the earlier round of litigation.
So far as this case is
Yes,
concerned,
10% has already been released,
10% has already.
already been released.
Yes, Mr. Paske, you are appealing for?
I'm appealing for
NBCC.
respondent number 9 to 13, NBCC.
Acquiring
I
department.
was the implementing agency.
Implementing agency.
Implementing.
Acquiring agency is the Ministry of
So we are mostly concerned with the state and the.
State and the Ministry of Home. Now there is no dispute with regard to the compensation. Now only there is a miscommunication between the state and the. They are saying that we haven't received the draft award. State is saying that we have already sent.
So the 10% advance was paid on what basis?
No, my lord, because some amount has already been deposited into the account of the district council, deputy commissioner. In the earlier round of litigation, based on the direction, they have released whatever the amount were lying in the account of the deputy commissioner, that has already been disbursed. That
How do you say it is 10%?
my lord, the record.
Until and unless the valuation is done.
No, my lord, valuation has already been done, lordship. Valuation has already been, an amount has already been given, lordship.
No, but then you say that no award was not prepared.
My lord, that is the stand of the Ministry of Home, lordship. Now government,
Was there any initiation of lending?
that has already been completed, lordship.
Here it is
Already been completed,
done.
lordship.
Lordship, the only problem is that 10%, it is the admitted fact that 10% had already been paid, Your Lordship, to the claimants, Your Lordship. And 90%, Your Lordship, is yet to be given by the Ministry of Home Affairs, Your Lordship, to the state.
To the state.
If this money comes, then Lordship, that will be done.
That is why the presence of the DSGI is important, Lordship. So today he is not available. Only we need some direction.
No, but then you see, like the order says initiation of land acquisition proceedings, but then initiation has been.
My
You say
lord,
that has been done.
That is so far with Southwest Garo Hills, Lordship. South Garo Hills, Lordship.
Yes.
In
You see,
my
until
case-
unless clear submission comes, that becomes very difficult.
My case, there is no.
Basically, it leads the court to pass wrong orders. Now you say that here acquisition was done; it is completed already.
My lord, the draft award has already been sent in way back 2017-19, Lordship, 7-19.
No, whether the notifications were issued.
That all 2015, Lordship, that has already been done, Lordship.
Is it correct, Mr. Sulai, that
Lordship, I think the first phase, because there are two phases, Your Lordship. This is the second phase, Your Lordship.
So first,
Second
phase,
phase,
they have
offence.
already paid, that is the stand.
right now we are concerned with which phase?
Lordship, we are
Second phase.
Second phase.
And first, so far as the first
phase
concerned,
already carried out.
there is a,
That is
there no
35 years back.
And the petitioners are not affected by the first phase.
No.
Are they the effect?
The stand of the ministry as well as the implementing agency was that they were already paid during the first phase of fencing. Because that time the implementing agency was BRO. I was inducted as an implementing agency by MHA for the second phase of fencing.
This is with regard to second phase.
Clarified by the MHA.
Yes, where is Dr. Majika?
If Lordship kindly have my instruction, that is the instruction dated 21 April.
The instruction which you placed
on the last
time, yes.
occasion, Your Lordship, yes. If Lordship kindly have a second paragraph.
Wait, that is. It is not here. Perhaps it must be kept in some other files, this disposed of file.
Then we'll.
What does it say? Just
Lordship will say further Southwest Garo Hills Ampati had completed the land acquisition proceedings since 2018. However, 90% of land compensation amount to 2648 crores is yet to be received from the MHA. So that is only pending, Your Lordship. Once the money comes, Your Lordship, then the state will.
So there is not much complication. Only
No,
Lordship.
Lordship. No.
Yes. It is pending from 2019. Yes, one prayer made by MS Archival Data. Council appearing on behalf of Dr. Majigal and DSA. And Falcon, council appearing appearing for the respondent, respondent Union of India. For the twist time is granted. Obtain necessary instruction. List accordingly, yes.
Masala.
Next item, my Lordship.
7 also is connected.
Same. You are also
I am for the 7, Lordship, and she is for this item number 6.
just record the names.
Obla, Your Lordship.
Item number 9.
Your Lordship? Yes.
In this case, we are aggrieved by the diversion of fund.
My apologies, my lord. I'm making the same prayer.
Again, Mr. Kharwanlang.
Yes, my lord.
Yes, so prayer made to clear the status. By Spencer. This matter after 2 weeks.
This is a long pending case since 2020.
All cases are long pending before this.
But only for small issues.
There are longer matters than this.
Highly obliged.
10.
Please, Your Lordship. Bishop,
Yes.
item 10 and 11 are connected. Now, what my instruction is that the matter has been resolved amicably, and the government has also issued us an order.
Again, Mr. Kharwanlang.
It's not there. So, Lordship, when we pray in matter come up after 1 week, I'll place this on record.
Pass it on to the other side also, so that Mr. Kharwanlang is still giving him whether it will do or not. But then that has to, Mr. Kharwanlang is representing state, isn't it?
My lord.
So, just whatever you have, just pass it on him.
I've followed.
Just say,
Matter settled.
just say on prayer made with the parties, list after 1 week.
1 week, Your Lordship.
Mr. Kharwanlang will be available after 1 week.
Then I'll pray for 2 weeks in that case.
Where is he? What happened to him?
My lord, probably he's not
Okay,
keeping.
2 weeks. We'll have it. Any problem in that?
None, Your Lordship. Let be. Lordship, liberty may want to bring this on record by an affidavit, Your Lordship.
Is it needed?
Needed, Your Lordship, to close the matter.
What is your document? What is your document? What does it say?
If I may please, Your Lordship. Basically, they've revoked the suspension of the respondent number 1.
So nothing remains.
Nothing.
We file a suit. These are 2 revisions we file arising from the suit.
The suspension is under challenge here in this matter.
Lordship, what will happen is we had filed a suit before the lower courts. Now, these CRPs arises from 2 miscellaneous applications filed by the state, Your Lordship. Their file got rejected. Now they've come by revision petition in this court, civil revision petitions.
But then this.
But the entire matter revolves around the suspension of the
So that
respondent.
is, once it is
This is
revoked.
resolved, the suit becomes infructuous as well.
Yes. So that is what. But then if it is the thing, then and this is a communication by the government officer.
Government itself.
It's okay. Anyway, if you want to bring it on record by affidavit, you can do it. But then otherwise, it may not be this thing. What he said, just say. You do one thing. Just say, Mr. Pasa, Learned Counsel, you are appearing for respondent number?
Respondent number 1.
Learned Counsel, you are appearing for the petition. Oh, sorry, appearing for the respondent number 1. Submits that the controversy involved in this matter has already been resolved by issuance of a letter dated 27th April 2026 under the hand and seal of the Commissioner of Taxes, Meghalaya, Shillong. Mr. H. Kharwanlang, Learned. He is additional senior GM. Is not available. Stop, Mr. Kapi Bhattacharjee, Learned G, appearing on his behalf. Praiseful. Grant us some time on his behalf. Start. To give say prayer, Lord. List this matter after 2 weeks. It will be open.
Corresponding to in item 11. I think so.
Just a minute. Let us finish the notice. Just a minute. It will be open for the respondent number 1 to bring on record the letter dated 26 April 2026 by filing an affidavit. That is what you want, isn't
Yes,
it?
Your Lordship.
Yes.
I'm responding to in item 11.
So these are both are this will be covered by this same order.
I have the instructions. And
In the second item also same.
10 and 11, my lord, two matters are there.
So identical, and that
Identical
is
matters.
that is also will become infructuous.
Will
because
become
of this.
fructuous.
You want it back? Take it back. Bring it back. Yep.
Bullet, Your Lordship.
Both will be same thing, only just
Parties.
consul's name and all.
14.
All right.
Wait, please, my lords. We have here.
One minute, Mr.
My lords.
Leave application. Leave application.
Yes.
Well, we are before your lordships challenging the order dated 34/20.
Before you start, there's a caveat. We'll discharge the caveat first.
One is caveat. Other thing, they have filed along with this an application for leave of this court to allow them to hear this application without a certified copy being. So that application also will have to be discharged. And other thing, my lord, initially I'll just take up.
That is between the court and the party.
Yes,
See,
and
you
other
don't
thing
have-
I'm just taking up, my lord, they have filed this application both under 227 and 115. That is my humble submission, my lord. 227, the set of power is altogether different, and it cannot be clubbed together. Because in the High Court rules, there is a separate chapter, my lord, for filing a revision application under 227. Powers are altogether different under 227 and 115. It cannot be, my lord. Either it can be under 227 or it can be under 115.
Let it be under 227 minutes. I have no difficulty with just maintaining 227. Because my prayer before your lordships, when my lordships would hear my prayer, I don't think my learned senior would then object.
Discharge the caveat first.
My lords.
You have been supplied with a copy of the.
Yes, yes, I have received.
Yes. You represent the caveator.
Yes, my lord. That is opposite party number 1.
Respondent number 1.
Okay.
Respondent number 1.
Just say in the caveat petition. Just say. Session Honourable Council appearing for the caveator submits that a copy of the civil revision petition number 12 of 2026 has been served upon the
Obviously, yeah, I can't refer to it.
has been served upon him. Stop. This is caveat. The caveat as such is term discharge by allowing the caveator to oppose motion of the civil revision petition. Stop. Okay. Then what is that? What else? The other application?
Miscellaneous application number 9 of 2026. That is allowing leave to institute this revision petition without a certified copy.
Yes, Ms. Christ, will you just say? By this application, the applicant has sought for permission to present
Only for the time of filing, my lords may have a look at para 4, my lords.
Yes. This is an application seeking permission to present the civil revision petition against the impugned order dated 30/4/2026 passed by
Learned additional district judge.
by the additional district judge East Khasi Hills without production of the certified copy of this. it is submitted that since this application has been presented in an urgent situation, there was no opportunity for the petitioner to obtain a certified copy of the aforesaid impugned order. The prayer for the petitioner, the paragraph, the prayer of the applicant to present the connected civil related petition without a certified copy of the impugned order dated 30/4/2026 is allowed, with condition that the certified copy of the same should be placed before this court as and when the same is made available to the applicant. With the above, this application stands disposed of. Yes.
Well, it's a limited issue. Without taking your lordships through the pages, Malaj, I'll just quickly narrate what has happened over here, Malaj. I filed a suit, Malaj. This particular dispute pertains to, Malaj, the Church of North India, Malaj, which is in short called the CNI. Now, I was the bishop, Malaj, who was duly appointed. Now, there was some letter issued to me asking me to go on leave pending an inquiry. They say pending inquiry, go on leave.
By the administration?
By the headquarters of the CNI. So that's called the synod, Malaj. So what happened is, Malaj, I filed a suit before the learned civil court, Malaj, assistant to district judge, because, Malaj, under the constitution of the CNI, the power to send somebody, Malaj, on preemptory leave pending inquiry is not there. The constitution is very specific. You can cause an inquiry and you may remove that person, but as we understand in service jurisprudence, your lordships are aware that pending inquiry, Malaj, somebody is suspended. Suspension pending inquiry, that power is not available under the constitution. So that was my prayer number one in the suit.
It is not expressly provided in the constitution.
Malaj.
Can this exercise of the power
Malaj.
be termed as illegal?
Malaj, because it is prohibited. It says, Malaj, under what circumstances I can be suspended. The language of that letter says, Malaj, you go on leave. That is not envisaged. So, Malaj, I will first take your lordships. What is my prayer in the suit?
Happened? You presented the suit.
I filed a suit, Malaj. I said that power is not there. One of my first prayers in the suit is, Malaj, that power is not there. I seek a declaration that power is not there. So, I ask for an injunction, Malaj. Injunction is not granted. I go, Malaj, I file a appeal. In the appeal, Malaj, what happens is, an injunction order is passed saying that maintain status quo, don't do anything for a limited period of time. On the next day, Malaj, the respondent number one, who's not a party to the suit, and Malaj is the so-called Shillong pastorate. Malaj, it's if I can explain, it is the synod. Below that is the bishop, Malaj. Below that is the pastorate. The pastorate is not involved. Pastorate comes in, Malaj, files a review application before the same court, saying that, Malaj, that there has been suppression of material fact by me. Now, what is that suppression, Malaj? There is, I'll take your lordships, there are three communications which are important, Malaj. The first communication says you go on leave, hand over charge to Mr. X. Second communication says, Malaj, within the 16...
Are you arguing no merits?
Malaj, I'm just giving you the facts before you.
You have to confine to the jurisdiction.
Malaj, I am only on that issue. I'm coming to that. Why I'm giving the factual backdrop is so that your lordships appreciate what is there. Malaj, the second letter says, Malaj, within so-and-so date, either you hand over or it would be deemed that you have handed over possession. Charge, not possession, Malaj, charge of the post. Next day, the letter they say, Malaj, I have suppressed. A meeting is convened. I am made to sign on a piece of paper, which is a handing over, taking over. So they come with that. They say, Malaj, you have suppressed. So the learned First Appellate Court, Malaj, in review by a third party who is not involved in the suit, passes an order recalling the order, saying that since you have voluntarily handed over, there is nothing that survives for us, and you obtained an order by suppressing this material fact. Now, I am aggrieved by only one word in that entire order, Malaj. It was never voluntary. Because the moment I say it is voluntary, my lords,
Where it is voluntary? In the order.
the order says it is voluntary.
So, at the stage, especially,
My lords,
when court was considering prima facie case,
lordships,
could not have made that observation.
absolutely, my lords. Because if it is voluntary, it has to come from me.
But then it will be read down
No,
accordingly.
my lords, that is why, my lords,
That is
unless...
an observation of the prima facie.
No, my lords, because it does not say. There is a finding against me. Now, this finding will preclude me from going and pursuing my suit. Basically, my lords, I get non-suited. If I say, my lords, if an appellate court says, no, you have voluntarily handed it over, matter ends.
So if that be the thing, you can clarify.
I'll just take your... Yes, my lords, I am before your lordships only on that limited issue.
Can revision jurisdiction be exercised for seeking clarification of that or this?
My lords, it's not... I cannot go back before the same
Where is
court.
that order? Where is that
I'll take your lordships to the impugned order, my lords. Page 2. My lords may kindly come to page 222. 2 paragraphs, my lords, I'll just take your lordships on it. Well, if my lords kindly have page 232, para 14. I'll read para 14 for my lords. My lords have para 14 means. This court, after hearing the learned counsels appearing for the parties on perusal of the review petition, in particular Annexure 4, which illustrates that Annexure 4 handing over, taking over charge dated 17/4/2006 executed by the opposite party appellant voluntarily, my lords, was not brought to the knowledge of this court in RFA number so-and-so.
That is okay, that is in convention. This is not a...
No, my lords, this is a finding against me. This court, as such, has passed the order dated so-and-so on the materials, placing before it excluding Annexure 4, handing over, which the charge dated so-and-so, which opposite party admitted is not part of the pleadings and documents in RFA number so-and-so. The learned counsel for the opposite party had earlier impressed upon the court that on the date of hearing on 23, the opposite party appellant was still holding office. Hence, this court granted interleave erroneously under the bona fide so-and-so had not demitted office without being brought to the notice of the existence of Annexure 4 in review so-and-so. As such, it is in view of this court that the opposite party appellant has come before this court with unclean hands by suppression of material facts and secured ex parte interim relief otherwise not entitled.
Anyway, these are finding recorded in the permanent state. See, it's a...
Well, what should have been done is...
Only...
Well, I cannot be here in advisory capacity, but your lordships are aware. When your lordships pass these kind of observations, it's usually said that it is only for the purposes of deciding this review.
Or maybe it can be said the purported letter, this is 74.
Lordships.
That will...
No, and your lordships may kindly have a look at para 22. I am only aggrieved by that one word, my lords, otherwise I am not aggrieved. Very well, I'll go and contest my matter elsewhere. Para 22 at page 236, your lordships may kindly see. I'm sorry, my lords.
No, but then does it debar you from contesting the case?
My lords, my prayer goes...
See, you have to go and contest it before the same court.
My lords, I have nothing left. If I have voluntarily...
Just a minute.
My lords.
Let us finish.
Lordships, I apologize.
You say, but then is it not that you will go and appear before the same court to contest your matter? The appeal has not been disposed of?
Appeal is disposed of, my lords.
Okay, appeal is disposed.
Disposed of.
So you will not be going
there. Nothing.
So in such a case, these will be binding on the
lower court. Which is why I have to come before your lordship seeking a clarification. Yes. Para 20, your lordships kindly see in the present case, the opposite party appellant and RFA number has without any reasonable justification suppressed the fact so-and-so has voluntarily, again this word voluntarily, handed over charge of his office to so-and-so, so-and-so. Then para 22, my lords. It is hereby recorded that the conduct of the opposite party is unquestionably an abuse of the process of law and has resulted in wastage of precious judicial time.
Just the previous paragraph you were reading, paragraph 22.
Para 20 I was reading first, my lords. In the present case, OP, at page 236, my lords.
Yes.
In the present case, OP appellant and RFA number so-and-so has without any reasonable justification suppressed the fact that OP number so-and-so has voluntarily handed over charge of his office on so-and-so to so-and-so. And then at para 22, my lords, certain aspersions are cast against me.
That is okay. So that is the only thing.
That I am only concerned with voluntarily. And why your lordships will kindly see? My lordships may kindly have a look at prayer 1 of my suit. Just give me the page. Page 70, my lords. Just why I say, my lords, this will become a difficulty for me. At page 70, my lords, is my suit.
70.
70. The prayer in the suit, my lords.
Yes.
Well, it's A, pass an order declaring that the executive committee of the defendant number 1 does not have the power or authority to suspend the plaintiff pending completion of inquiry as per constitution of the CNI. So if I have voluntarily handed it over, my lord's, matter comes to an end. And that's what is being argued by them, that you have voluntarily done it. Why are you now espousing the matter before a court? My learned senior has argued this issue before the learned first review court, that you have voluntarily handed over. Now why you are coming and agitating it here?
No, he could have argued that, but
No,
then
my lords, it is open for my learned senior to argue that, my lords. But it is not open for the court to say something is voluntarily, especially if that letter does not say that I voluntarily handed over.
should not have been passed in the manner of recording a final
finding, my lords. Because that finding will render my suit.
Yes, Mr.
That's all.
Yes, no, my lord, if I can just, Lordship need to know the facts. Why I am saying voluntarily and why the court has recorded it's voluntary.
See, there is no problem with that. The word
I'm just
voluntarily, you see, the thing is that whether it is voluntary or not voluntary, it can be determined only at the end of the adjudication, isn't it? Now, yes, what you say, prima facie, it may carry weightage. But then in such a case, court should have said that prima facie it appears. The letter is voluntary. That can be the basis and that can be well clarified here. There is
What I want to say, Your Lordship, now, my lord, after they were not granted an injunction by the trial court and fixed the matter, my lord, on 30th of April, what happened on 17th, my lord, this is very crucial, on 17th April 26, my lord, they voluntarily handed over by executing a letter, my lord. That was not unilateral. That was done. I'm just coming, my lord.
Just a minute. That is during the course of the pendency of the suit.
Yes. Yes,
after the suit was filed.
After the suit was filed. Now they have done it. My lord, office was taken over by the new bishop. Everything was done. Now, my lord, this is important. On 22nd April, that happened on 22nd April, they filed an appeal. I'll take my lord to that appeal. What they have written, not a whisper. Even suppose, assuming that under some duress, it's not voluntary. There is not a whisper.
About the...
Not a whisper.
About this voluntary, this thing.
Not a whisper about any kind of handing over.
So that is okay. That is okay. All
Well,
right.
What happened, Your Lordships?
But then, the problem is that...
No.
What you say...
Lordship.
These are all actual aspect. But in the merits of the case, that will remain.
No, my lord.
That will remain there to be taken at appropriate time. Okay. Here only thing is that if the issue before the appellate court was only the interim order, in such a case, where was the scope for the court to record some finding which appears to be final in nature? Mr. Paul's prayer is not here. You set aside this order. It will remain.
No, my lord.
The thing is that this observation to be read as a prima facie finding, nothing else.
My lord,
so that it, it
Lordship,
remains open.
My lord, the other thing, Lordship will see, my lord, in their pleading, there is not even a whisper. See the conduct. Not even a whisper.
Are you seeking rejection of the suit at this stage? Can you do it?
No, I'm not.
Even if we assume that whatever you say it is correct.
No, my lord, I'm not saying this. Now, my lord, I have served a copy. We filed this, man. We filed our review application, making a clear categorical statement supported by an affidavit that handing over was done voluntarily by the bishop. And we have used the word. We served a copy on the council. He was granted sufficient time. If he wanted to controvert, my lord, he should have filed a reply to this. He is entitled to file a reply. These facts were brought to his notice. He was served a copy, given sufficient time. He did not.
So what is the consequence of that?
The consequence of this, my lord, he had not submitted. But this court will have to go by the pleadings.
Assuming that he has
This
not
is a
done
civil
it,
proceeding, my lord.
assuming that he has not done it,
My lord.
was it proper for the appellate court to record this finding which appears to be final in nature? In absence of...
My lord. My lord, if there is no, my lord, if it is not controverted, and I have made a statement on an affidavit.
Then what would remain in the suit?
My lord, this injunction matter has not been rejected. This injunction matter is coming up for consideration, my lord, on 20th of
But then is it
this
not
month.
that the
My humble submission.
will be bound by the observation of the appellate
My lord
court?
will be see one thing, my lord. They should not have done the mischief. This amount to mischief, my lord. What they did before the appellate court.
Raise all those things at the
No, I have
appropriate
raised.
time.
No, I have raised it. I have raised it before the appellate court, pointed out this thing, pointed out the letter, my lord, and what order passed by the appellate, what ex parte order they obtained from the appellate court, my lord. It's not status quo. Entire communication was stayed by the appellate court, relying solely, my lord, on the materials placed before that court.
But anyway, the appellate court has
Relied on the materials.
reviewed that order.
Now, what has been withheld, my lord, this vital piece of communications, which was signed, if I can take my lord to that communication. What is that communication?
We do not know, Mr. Shen, why you are prolonging the submission. Just say. Even say, supposing what you see.
No, lordship
Say,
will seize.
Even it appears to be correct.
Man.
Can we accept that thing and pass some order dismissing their suit?
No, my lord, there is no question. My lord, what happened? One more thing I'll just point out. This impugned order,
What's
which
the
is.
purpose of pointing out that is
No,
before this court?
No, this is relevant, my lord.
The issue here was
30th
is
April.
only one thing, matter pertains to jurisdiction, the exercises of jurisdiction by the court, whether there was a proper exercise or improper exercise.
Lordship.
The question comes whether appellate court,
Lordship.
while dealing with a matter concerning interim prayer,
Lordship.
could have given a finding which appears to be filing an adjournment. That is the only issue.
No, that one lordship can.
That is the only
No, my lord.
issue. And say supposing if we grant the prayer which Mr. Paul has made right now,
Lordship.
that will not have any adverse effect on you.
My lord, what I am submitting, your lordship. Now, this impugned order was passed on 30/4/2026, my lord, at around, my lord, 2. And the matter for injunction before the trial court was also fixed on that day, and it was taken up in the afternoon. So, my lord, they appeared, all the party appeared there, my lord. This communication was with them, your lordship. This letter was with them.
Mr. Paul, what is the urgency? Just tell us.
And, my lord,
You
this
could
matter
have-
is now
could have-
posted on
could have
20th.
Tomorrow, day after.
The agency is, my lords, I'll point out. I filed an additional
High Court
affidavit.
is not finally disposed of.
No, my lords. What has happened is now, yesterday I have been given a communication by them, the respondent number 2, my lords, which says that today at 11:30 I was to appear for that inquiry because he
but
said
there
you
is no
formally
injunction.
voluntarily handed over. So now we're going to proceed with
So,
it.
virtually, what they want an injunction from this court?
I am not asking.
That is what they want.
But let's, the two aspects your lordships will kindly
Mr.
appreciate.
Paul, which
Or you allow me, lordship, I'll.
Kindly allow the court. When the court is speaking.
Sorry, man.
See, the indication which you gave at the time of mentioning was something else.
No, my lords, that's what I'm saying.
No, but then if you even interfere with these two observations, or
My lords, then I can go and follow my legal remedy.
That is, you see, it doesn't differ if this since the injunction matter is still open, it has not been closed.
Lordship.
Definitely, you can raise this before trial
my lords,
court.
my difficulty
Now
will be-
I can understand the difficulty which you have. Yes, that you can bring before this court, but then it was not that very urgent.
My lords, my difficulty is because of this new letter which has been issued to me yesterday.
We'll have it next Monday, Mr.
I'll file an affidavit.
It is
if
not
necessary.
something very urgent. Not very
Virtually now they're seeking an injunction from this court.
I am not seeking an injunction. I've made my prayer before your lordships.
That is okay, but then
cannot
the
add one more.
clarification also, you do not need it at this stage. It could have been obtained after 2
My lords,
days.
my difficulty is against this new letter. If I go and file an application before the learned trial court, my lords, I will be stuck with these observations, which is why I was forced to
Court
mention
has
the
not
matter.
taken it up for consideration as yet, my
When
lord.
the matter before trial court is coming up again?
20th, just my
We'll
lord,
have it
few
next
days. It is for
My
the
lords would
court.
want
He
to
can
have
take
it
up those submission, my lord,
My
before
lords,
the court.
the very interesting part is, my lords, my learned senior is appearing here for a non-party in the suit. They have
But
not
I
gone
am
and
a
filed-
agree party.
they
I
have not
satisfy
gone-
that. I am
they
a
have
agree
not gone and
party.
filed a-
He's a
Review
party
is
here.
open to the agree
He's
party.
party here in this case.
My lords.
That is good enough. Mr. Cavator, you have supplied a copy.
My lords, I
If
have
necessary,
to.
I will file an affidavit, your lordship, in this case.
Affidavit is not needed here.
My lord.
We do not want to enlarge the issue here.
My lord,
Do not
what my
want to
learned friend is submitting here, he can take up all this plea there, my lord. I don't know.
I will just take your lordships to my learned senior's argument before the first appellate court. And if anything is left for me to argue,
Why you both of you are stretching the matter?
I don't want to.
Beyond what has been prayed for.
I bow down. I bow down. I follow what is following for my lordship. I bow down. Lordships, I have it on Monday.
Yes. Hard. Not that senior counsel opinion for the petitioner. Mr. Paul Lane, senior counsel for the petition, assisted by so and so, and also Mr. Shen appearing for.
I am appearing for opposite R1. Respondent number.
Yeah.
R2 and 3.
Have you received a copy? We just supplied them also.
We'll ensure.
Okay. Ms. Rahman, also Learned Counsel appearing for the wanted. We are not passing any order. Please tell your team to supply a copy to
Well,
Ms. Rahman. So service other is complete.
Lordships, I undertake, your Lordships, record my statement. We'll serve it in the course of the day.
How many respondents are there?
3, my lords.
You are appearing for?
1.
1. You are for 2 and 3.
2 and 3 are the original defendants in the suit, my lords.
Yes.
1 is not a party.
And you are assisting Mr. Shan? Yes. Okay. Mr. Shan, case was so and so, and Mr. Shan, elect a copy of this petition we supplied to Ms. Rahman, Learned Counsel, appearing for the restaurant number 2 and 3. Release this matter. Given Monday.
My lord, instead of Monday, your lordship, if you can post it on Tuesday.
Tuesday again, sir. I'll have that. It's a very short issue.
No, my Tuesday, because I have some difficulties, your lordship. Tuesday or Wednesday?
Wednesday, my lords.
Wednesday. Seniors, you should sort out the issues at least.
I don't. Whatever your lordships feel appropriate.
Drag the court even to the issue of settlement of dates.
Well, I apologize.
Yes, just say list again. Give Tuesday's date also for
Wednesday, my lords. If it's not inconvenient.
Mr. Shan will be more happy. So for further consideration.
Well, I am seeking leave to file an affidavit. We tried to file the affidavit. The registry said leave will have to be obtained for my lords.
What for? What affidavit?
Bringing that fresh letter on record, my lords, by way of an affidavit.
Will it be required for consideration? We will not go into the facts, Mr.
I am only saying, my lords, we'll bring
only
it
if you say that something was a part of record, it was ignored, definitely we look.
No, this is not part of record. But it's happened
We are
after.
more concerned with the exercise of jurisdiction. Nothing, not about the merits of the case.
My lords have got the crux of the matter.
My learned friend is, senior friend is smart enough, my lord. What he is ultimately seeking, while seeking an injunction from this
I am
court.
not. I'm saying it in so many words. No. As a matter of fact, this matter could have been disposed of with a one-line observation from your lordships, as your lordship said that this can only be a prima facie view.
That is what. But then since they have some reservation and they respond number 2 and 3, they also basically.
They may want to say something. Very well. Have it on Wednesday. Well, it's whether your lordship will grant me leave to file this affidavit. We'll just file it, my lords. Your lordship may consider or not consider.
These are new developments. All new developments.
Anyway,
Since there is no injunction, of course, my lord, they are proceeding with the inquiry.
Granted to the petitioner to bring on record. This is a new document, not a part of the suit.
After, because it has happened after.
Because there is no injunction, so they proceed.
Bring on record.
Well, this is communication
necessary
dated.
document which is not already a part of this revision petition. What you said, liberty is granted to so and so to bring on record, which is not a part of the revision petition, by filing an additional affidavit.
Yes, I'll oblige.
All right.
Nothing.